Whenever you're ready, please feel free to let us start. Thank you.
Right, thank you, Chair. As we're waiting for the delegation from Sierra Leone to join us, maybe we can extend it to another 5 minutes, if it's okay, so that at least we all started around 4:06.
Yes, most definitely. That will be in order. So whenever you feel we can kick off, just initiate the conversation. We will be on standby. Thank you.
Hello, everyone from Sierra Leone. I think Abigail will soon join.
You're muted.
Hello, apologies from Freetown. Can you please just give a few minutes? I think a few of them are having IT challenges. Just a few minutes network issues. Thank you.
afternoon, everyone. I think we can start now. I can see that we've been joined by Abigail from the Attorney General's office. Abigail, how are you? How's Freetown?
Good afternoon from Freetown, and I think I recall Asante Sana.
Yes.
Yes.
So just wanted to confirm that the delegation joining us on the panel are on the call, and whether we can proceed to start.
I think the minister will be joining us shortly. But I must indicate that they have an engagement as we speak. But I think they will be joining us any minute from now. We have the Armed Forces Day today in Sierra Leone, and we are honoring our fallen heroes. So they are currently there at that ceremony. But he did indicate that he will join us for a brief moment.
All right. Thank you, Abigail, and now officially starting, welcome to today's event. It is a sensitization symposium that is held in partnership with the Chartered Institute of Arbitrators Kenya branch and the Minister for the Office of the Minister for Justice and the Attorney General of Sierra Leone. My name is Evelyn Kimani. I'm the acting CEO of the Chartered Institute of Arbitrators Kenya branch, and we're very excited to host you. I can see now we are at about 73 participants and still counting, which is a very, very good thing. And I know from our registrations, we expect many, many more. I can see a very healthy delegation coming in or joining us from Sierra Leone, and a few of our members here at the Kenya branch. So maybe before we can start off the substantive agenda of today, allow me to highlight as to who the Chartered Institute of Arbitrators is and what it is that we do and the reason for this symposium. Now, the Chartered Institute of Arbitrators, known as Ciarb Kenya branch, or rather C.Arb, is an international organization, a professional membership organization in over 47 countries right now, and started in 1915. So our HQ is in London, and Kenya branch is one of the biggest, I know I can say that, Mr. President, one of the biggest and most vibrant, not only just here in Africa, but across the globe. Kenya branch was established in 1984, and it has gone ahead to support various branches across Africa to establish and to start, including Rwanda, including Zambia, Nigeria, and actually most of the branches that we have in Africa. So Kenya branch has a membership of about 1,500 currently and still growing. And the main aim of the Chartered Institute of Arbitrators is that it is the thought leadership body that is mandated with the promotion of arbitration and ADR across the globe. So you'll see that, for example, if we look at Cesar's name there, it has C.Arb and FCIArb. Probably the Professor Wyne's name has the same thing. That is to show that a member belongs to the Chartered Institute of Arbitrators, and either an arbitrator, mediator, or a construction adjudicator. Now, in terms of what it is that we do as an institution, we train and capacity build in arbitration and ADR. That means that we have pathway programs which are anchored within your membership, such that by the time that you're starting your journey, you'll keep growing within the ranks of the Chartered Institute of Arbitrators. So should you choose a pathway in arbitration, a pathway in mediation, a pathway in construction adjudication, you'll be able to raise within the ranks of associate member, fellow, all the way to chartered arbitrator. So it is a pathway to excellence that the Ciarb has curated to ensure that constantly arbitrators and dispute resolvers are always honing their skills and growing within the ranks. As an institution or as a membership institution across the globe, there are over 20,000 members, and these are derived from literally across all professional backgrounds. So I'll give the example of here in Kenya. Of the 1,500 members that we have engineers, we have architects, we have business people, we have lawyers, we have people within the quantity surveying sector, we have accountants such as myself, and literally even medical doctors. And the reason for this is you'll get to appreciate that disputes have no boundaries. You go to a particular sector, there are disputes. You go to engineering sector, there are disputes. You go to the finance and banking sectors, there are disputes. So the way ADR is framed, or the way it works, and especially in arbitration, and especially within the disputes within a particular sector are best handled by people within that particular sector. So for example, should a dispute arise in mining, we have professionals within that particular industry who can then be able to hear that dispute. If a dispute arises within the built environment, we have professionals within the built environment, with architects, engineers, or even quantity surveyors and construction managers within that particular sector who are competent enough to hear that dispute. So what that does is that it expedites access to justice, because you'll appreciate that a person or a professional within a particular sector is likely to understand the intricacies of that dispute. So in terms of the membership, and I know we are being joined by several people, not only within the justice system of Sierra Leone, but also the public and the private sector. It matters not from whichever background you're coming from, or from whichever professional background you're coming from. Anyone can become an arbitrator, anyone can become a mediator, anyone can become an ADR practitioner. Now, having said that, the reason as to why, as a Kenya branch, we've partnered with Sierra Leone and the Office of the Attorney General for this symposium is that part of the work that we're doing is in promoting arbitration and ADR, but most importantly, enhancing access to justice through arbitration and ADR. When we started having this conversation with the Office of the AG in Sierra Leone, the idea was for the Kenya branch, having been there and done that, how is it that we can be able to, assist similarly to what we've done with the rest of the other branches that have been established within Africa, and support and ensure that we are assisting the office to create awareness of arbitration and ADR. And that is the fundamental pillar for today's event. We are hoping that with this particular sensitization symposium, which essentially creates some sort of awareness about arbitration and ADR in general, and now getting into the nitty-gritties of the ADR and arbitration framework within Sierra Leone, and how much not only the various stakeholders, including the Ministry of Justice and the justice system, the private and the public sector, can then work hand in hand to ensure that the frameworks that are there are operational. The people who are there have embraced arbitration and ADR, so that it becomes an expedited way within which people are able to acquire justice efficiently, affordably, and most importantly, using people-centric mechanisms. So having said that, we're very excited to host you. We're very excited to have you join us, and we're very excited to establishing this working relationship, hoping that it will be able to bear extremely good and impactful fruits going forward. Over and above that, we are training institutions, as I mentioned. So all the trainings that happen within arbitration, mediation, and construction adjudication, we are ready to support. And as the chair mentioned, as we were starting, I think we've already trained a number of people from Sierra Leone last year, and we're hoping to support that as we go along. The other thing that I'd like to highlight at this particular point as we start is that not only are we going to be here and supporting in terms of creating numerous platforms for awareness, because I know not many people, and this is something that I got, not many people have gotten exposure to arbitration and ADR. So we'll be there on standby. It need not be very, it can be customized. That's what I'm trying to say. We have the generic training, and normally this is usually the structured training, but we also understand the intricacies of different sectors and different needs. So we are also very open to curating customized training that addresses those particular needs, so that we are not only looking to build arbitrators, mediators, and dispute resolvers, but we're also looking to create a systematic way or a systematic way of addressing these things, which include policy and frameworks for institutions that look to embrace more of ADR as a dispute resolution mechanism of choice. We're looking at thought leadership in terms of how, in terms of the many more conversation we can have around arbitration and ADR moving forward. Now, I have just highlighted in a summary form what it is that the Chartered Institute of Arbitrator does. And now we'd like us to get into the nitty-gritties of today's agenda, where we are looking at arbitration and ADR, creating a sustainable pathway for dispute resolution framework within Sierra Leone. And we are joined here by a stellar panel, and you're very, very lucky to have the president of the Chartered Institute of Arbitrators globally, representing the interest of over 20,000 professionals drawn from over 47 branches across the globe, as well as our chairman at the Kenya branch, Professor Wyne Mutuma, a multifaceted professional who essentially embodies the fact that dispute resolvers need not belong to any particular professional background. We're also joined by our chair emerita, Jacqueline Waihenya, chartered arbitrator and fellow of the Chartered Institute of Arbitrators. Jackie is an advocate of the High Court of Kenya, as well as a leading champion of interest of women in arbitration across the globe. But also over and above that, she's the current sitting chairman of the Institution of Corporate Secretaries here in Kenya. So we're in very, very good hands. And I know we will be joined later on by the Minister for Justice and Attorney General of Sierra Leone, Honorable Alpha Sesay, as well as the Deputy Minister of Justice, Honorable Elizabeth. So Chairman, allow me to hand the baton back to you, and you can start us off as we navigate this particular conversation and await for the Attorney General to join us. Thank you very much.
Thank you so much, Evelyn, for that wonderful introduction of all of us. I am so pleased. I wasn't sure actually whether this session would have a full house. So I'm so pleased to have with us the president of the Chartered Institute of Arbitrators, Dr. Cesar Pereira. Cesar, it's such a joy to have you with us. I'll formally introduce you and the rest of the panel. I'll say why, because I think quite a number of our members may have seen our alert with some of the logistical issues we've been having at Jomo Kenyatta International Airport. So we weren't actually sure whether he would be able to join us. Thankfully, he's been able to join us virtually. What we had intended initially was to have a hybrid session with a few of us at the offices and then have some of us joining from virtual platforms. So it's great to have you with us. But just again, by manner, in way of announcements, we shall have him present with us from sometime tomorrow from 3 o'clock. So we'll be communicating formally with our membership on that. Interestingly, Cesar, this dovetails with a lot of what you're doing. I think your presidency has started off with a very valuable innovation of trying to get branches to speak to each other and to learn from each other and to grow their experiences. And I think that hasn't been quite as emphasized in the past. So in our miniature sets, what we're doing here between Kenya and Sierra Leone sort of fits that paradigm. We are very much looking forward to other conversations of that nature. Later on, I think please look out for our announcements. The Kenya branch I think we'd sent out a rota. Last time it was I think about 2 weeks ago, a week ago, it was enjoyable to listen to the collaboration in experience sharing between Nigeria and Brazil. So again, we will share that in terms of announcements. Evelyn has sort of given us a sense of what we hope to achieve in terms of this symposium. There is a lot of work being done in Sierra Leone. We'll hear from our colleagues in that regard. A few of them are actually on the platform. Abigail, I think I saw Abigail. She was with us during the ADR week. We normally claim her as one of our own. We had started an illustrious process of citizenship with plans to make sure she doesn't go back to Sierra Leone. So it's really good to have her with us virtually. There are quite a number of other colleagues that I recognize who are present. I've seen them during the training sessions at the entry course, Module 1. So it's really good to have them with us. I also recognize the presence of the Emerita Solicitor General of the Republic of Kenya, Ogeto FCIArb. He's done so much work in this area, specifically with Sierra Leone. I think once the Minister of Justice joins, they'll recognize the kind of collaboration that they've had in the past. Welcome, Emerita SG. So it's really about getting to see what's happening in Sierra Leone. They will be talking to us about the Arbitration Act 2020, some of their thoughts around how to build institutional and practitioner capacity. I think cutting across this conversation will be the underlying importance of ADR in general terms, and of course arbitration more specifically. It's become more and more clear, at least in different parts of the world, that dispute resolution is really an economic strategy. It's a strategy when it comes to attracting investment. So we are trying to see how best to profile broadly the African continent and then specifically individual countries through very effective dispute resolution mechanisms that enable those countries to attract investment. Share a lot around the Kenyan experience of this. I think Kenya has developed at a rapid rate, a lot of significant landmarks when it comes to ADR and arbitration specifically. She's been at the center of a huge amount of work when it came to judiciary, that part of the ecosystem that requires the judiciary and its support, whether through the court and next mediation. I think her tenure also has the landmark of 6 Supreme Court justices that became fellows, but just not on the strict ADR lens. I think there's a lot happening in Kenya when it comes to community justice systems and what is more popularly referred to as alternative justice systems. So I think that will be quite useful to share. Sierra Leone also has some experience on how those traditional systems have been helpful. Our colleagues from Sierra Leone will speak at length when it comes to updating us on the history that predates the 2022 Act. And of course, quite a number of international treaties that both countries are a part of and how it plays out in their own domestic settings. The New York Convention, the 𝐾𝐢𝐬𝐭𝐢𝐧𝐠 Convention, just to name a few. I think one fascinating area for us now that Kenya is also going through some law reform is how they've introduced very novel aspects in their 2022 legislation. I think you'll see they've introduced emergency measures, preliminary orders, third-party funding, just to name a few. So that puts Sierra Leone quite ahead of this conversation when it comes to law reform. In terms of approach, I will essentially give each of the panelists an opportunity to set the context. Cesar will be sharing with us the global context. So there are global perspectives, I think, both from an institutional lens, it would also, I mean, kindly feel free also to throw in something from the Southern Hemisphere, Brazil, and just to establish that global understanding. As I mentioned earlier, Jackie will talk extensively about the Kenyan context, and our two good colleagues from Sierra Leone, the Deputy Minister. I had noticed the CEO preferred Deputy Minister to use the name Elizabeth because we are busy struggling on how to pronounce your first two names. So you'll help us on the pronunciation. I don't want to massacre the name, but it sounds like Septu and Sako, Elizabeth Esquire. So she'll speak a bit on that context. And when the Attorney General and Minister of Justice joins us, I'm sure he'll give some overview of what that jurisdiction looks like. So, ladies and gentlemen, that's what we have in store. So, allow me at this stage then to invite the panelists just to give some context to the discussion. It's a very, very broad context, 10 minutes each. We'll start with our Emerita Chair, Jacqueline Waihenya, who has conveyed her sincere apologies that she may have to exit at about 5 o'clock for an urgent appointment. And then we'll move from the Emerita Chair straight to our colleagues from Sierra Leone, and then hopefully then finish with Cesar, who will then give us that global perspective. Welcome, Jackie. Good to have you with us.
Yes, thank you, Mr. Chairman, and thank you for also allowing me to go first. I do appreciate that concession, and especially since we have our global president in the room and in the house with us. And I think we're very honored and privileged to have him because I know Nigeria beat us to it, but we still do form one of the earlier branches that he is engaging with. So, Mr. President, I know you don't like me calling you that, but Mr. President, thank you so much for honoring us with your presence and also the support that we have felt before you took office and even now as you have hit the ground running. We don't take it for granted. And I think the best that we can do and say is that we'll continue to support you even as you do your tour of duty. And thank you, Chair, also for this opportunity to speak to an area that I'm very, very passionate about, that is arbitration and ADR. And I'm really looking forward to hearing from our colleagues over in Sierra Leone about the Arbitration Act 2022 and how it has reshaped the practice across the continent, all the way in Sierra Leone on the other side. So we're looking at our East-West collaboration here. And of course, with Mr. President being present, it's global and it goes also South-South. So I'm quite sure our engagement will be very exciting and we will learn a lot during this presentation. So I have seen Emeritus Chairman Calvin Nyachoti, and I've also seen Dr. Abayomi as well on the call. I just wanted to highlight that to you, Mr. Chair. I'm sure at the right time, you'll also give them an opportunity to say one or two things. And these are lessons from Kenya. And for us, I think we began our journey with this saying. I like this because I heard it very, very early in my practice, that every accomplishment starts with a decision to try. It is our version in Africa of every journey begins with the first step. So, of course, we've heard quite a bit from Evelyn and yourself, Mr. Chair, on ADR. I just wanted to throw in a little bit of flavor. Is it alternative? Is it appropriate? Whether we call it alternative or appropriate, arbitration and ADR are not really alternative. they are core justice infrastructure. And I'd like to emphasize investment and governance and stability, because those also happen to be my other areas of interest when it comes to practice and also in the academic space. So this is one of my favorite photos with the judge hidden behind the files before ADR. But after ADR, they are happy, they are dealing with core judicial issues. So that is why we emphasize that this is a core issue for infrastructure, and especially for investment, governance, and stability. So we have to build our ADR ecosystems very intentionally through institutions, policy, capacity, and trust. This word trust has become very key in governance in the recent past, because with the technology moving at the pace that it is, what is happening, especially in the tech arena, is an emphasis that we really do need systems that can work, that we can trust, that can get us to where we want to go. And we only trust them if we understand how they work. So we also have to be a key cog, a key wheel in the cog of justice. And as we move along, and I'm quite sure as we get into the future, because the future is already here, this word sustainable is going to be prefixing very many of the things that we do. And I expect that dispute resolution is not going to be left behind. So we must have a sustainable dispute resolution framework that supports the rule of law, investor confidence, efficient commercial justice, and social cohesion. And when I say investor confidence, then immediately, very critical for the symposium that we are having this afternoon and evening, is that everything that we do will always have a cross-border flavor. And of course, we have seen it already play out this afternoon in the East-West, in the South-South, and in the global dimensions that we are having to commercial justice. And social cohesion is very, very important because of impact as we move forward. We're very familiar with the main mechanisms in ADR. Of course, we are speaking primarily about arbitration, but the cousins always need to also go along: the construction adjudication, the mediation, the negotiation, and let's not forget litigation, because it also tends to be part of the ecosystem as the last resort. And in any definition, alternative usually means alternative to litigation. So let me deep dive a little bit into Kenya and what our experience of arbitration has been. And because the story of arbitration cannot be told without the story of ADR in Kenya. So we inherited the common law system, and everything in the beginning was litigation oriented. That was the culture when it came to dispute resolution. In fact, litigation was the beginning and the end of dispute resolution. So the ADR practice in the formal sector was very minimal. It was limited to maybe let us see if we can negotiate a consent out of court. And it took a while, but in 1984, the Ciarb Kenya branch was established by PAP, and I have to give credit where it's due, by practitioners in the built environment. Since then, the ecosystem has grown to include lawyers, architects, it's going to include surveyors, and as you heard our CEO say, we have even been able to infiltrate the accountants, and hopefully the financials will also get into this space. And we are looking also into other spaces. In 1995 in Kenya, we laid our legal foundation. In 1995 Act with the in situ principles. And since then, modernization then also took us in the direction of an institutional arbitration and act that in 2012, we had enacted the civil procedure on the next mediation pilot in 2016. I am mediator number in the pilot. We all thought to ourselves, oh, the way mediation looks like it's going to be it's going to be adopted so much faster than we have seen arbitration. it will eclipse everything. The truth of the matter, and I will say something about the success of the Quarter Next mediation program, is that the more we embraced mediation, the more, I'm not sure what the magic is, but the more we ended up embracing arbitration as well. So when you build one ADR mechanism, almost automatically it impacts the other mechanisms of mediation. And so in 2024, we had the session paper number 4, which is now our national ADR policy. It proposes 3 statutes to update the Arbitration Act, and also we came up with a dispute resolution bill, and the construction adjudication bill is also part of the national ADR policy. So what I'll say, where we are at right now, arbitration and ADR have become a very, very critical part of justice reform, and I dare say also economic governance. So for I think when we are engaging with our brothers and sisters across the borders or across the continent, it is important for us to emphasize that one of the key pillars of success for ADR in Kenya has been making it a part of our national economic architecture. We have to speak the language that the bankers understand. We have to speak the language that the built environment understands. We also have to speak the language that government and the 3 arms of government, parliament, also the judiciary and the executive. So we have to bring everybody to the discussion or to the table, so to speak. So what has been the role of C.Arb Kenya in building capacity? First, we have created an institutional backbone. C.Arb Kenya was very instrumental in including, you may have realized I spoke about the acts. I didn't speak about the constitution, but in 2010, we promulgated Kenya's constitution. Article 159(2)(c) refers to ADR, and it was deliberately included with the section dealing with judicial authority. And C.Arb's contribution was first to make sure that that article in the constitution was included. Our emeritus chair is now late and of blessed memory, and the then Minister for Justice in Kenya, he's the father of one of our leading arbitrators as well. They conspired, they colluded, they did the politics necessary to include Article 159(2)(c). And it has really, really had a huge impact on how we are able to practice arbitration and all the other ADR mechanisms, and also to give the courts, first of the language used is the courts shall promote ADR. So they have a legitimate constitutional basis for promoting ADR. Of course, there's a provision of supervision, and that has also, in its own way, had interesting outcomes. But the important thing is that we in Kenya have the benefit of having our ADR provision anchored in the Constitution. In addition to this, other than participating in law reform actively, we also, as a branch, I think we provide the structured training pathways. I've had this described as the platinum way of getting certified into the practice of arbitration. And I want to say I have, I don't think I have no fear of contradiction that we are indeed the best trainers and the most recognized. And I say this in the presence of our global president. We have the pathways that you're all familiar with. You start as an associate, you become a member, you become a fellow, and if your peers agree, you can also rise up to the exalted status of a chartered arbitrator. We have also been at the forefront of ensuring that ethics, competence, and procedural discipline is observed, is enhanced, and we continue to fight this battle. It's never easy, but nonetheless, we continue to be part of the engagement to ensure that we broaden this. What we have done in the recent past is to include these provisions in the C.Arb Kenya branch arbitration rules of 2020 And we also, I can say this because I was in the steering committee that led the legislation proposals. We also included a strong code of ethics to be adopted, not only in arbitration, but in ADR and in all the mechanisms. So, and also to provide a way to ensure competence and where necessary to ensure that procedural discipline is applied. So in the process, we've been able to build a very strong pipeline of neutrals, of arbitrators, of mediators and construction adjudicators. Mr. President, I think we rank amongst the leaders of the number of appointments that we have done or we continue to do. At least as I stepped down, we had done 400 appointments in the 2 years that I was in the chair. And I'm sure the chairman will also be able to update us on those numbers. In addition to training and ethics, and also building a body of competent arbitrators, mediators, and adjudicators, we also have been building capacity as a factor of sustainability. And this is with the recognition that ADR really depends on people beyond the laws. We also have to look at the people to make sure that we have engagements like the one we're having this evening, to ensure that we also have engagements with our colleagues across the borders, to just ensure that even after we certify our people, we also have non-pathway programs that we can enable our partners, our members, even those who invest in this space, to be able to support our CPDs, to also ensure that we have peer accountability and international credibility in the West. You can also accelerate reform through partnership with recognized institutions such as C.Arb. And the C.Arb family is large and it has a footprint in pretty much every part of the world. It's only when you step outside the borders that you realize, wow, we are quite a number. We are very well recognized and we tend to speak the same language. So we also tend to build many friendships, and I'm underscoring friendships because we tend to also have a social impact in that way. So beyond the institute, it's important to say that when we talk about the judiciary and the government, the way to go, and it's great that we have the Deputy Minister for Justice present and the Honorable Attorney General of Sierra Leone, we have been able to work very closely, especially with the judiciary. I know our chair, he emphasized that in the last 2 years, we were able to translate the entire Supreme Court to become fellows of the Chartered Institute of Arbitrators. I can tell you it was an exciting experience. It is not for the faint-hearted, because when you present your apex court for an exam, there's certain dynamics. You remember there are people, and remember they are very qualified and very competent, and the dynamic, they're also very busy people. So keeping them at any stage in the process when we're training them was an exciting experience, but I really sigh of relief. In fact, Mr. President, we took them to London to be received in London by the then global President Jonathan. And in the process, I think he even got a Kenyan name. And we are hoping that even when you come here, you'll also translate into a Kenyan name by the time you are heading to your next stop. But what I can say is that she really inspired so many members of the judiciary in Kenya. And the reason I thought fit to also share this photograph here is that when we took it, it was just for fun. But when I look back, it's one of those moments I felt, wow, we have done something. Because in this picture is also the Chief Justice of the Republic of Zambia. He also joined us for the Nairobi arbitration last year. which was hosted by my namesake and also a fellow chartered arbitrator, and the then chairperson of the Nairobi Center for International Arbitration. And with us was the chairman of the National Steering Committee of the National ADR Policy Committee. So our Chief Justice, our patron, has inspired so many other judges to voluntarily step up and say, well, if the CJ can do this, if the Supreme Court judges can do this, so can we. So it takes a champion to be able to collaborate in this ADR adoption. So of course, somewhere in there, Deputy Minister Dr. Elizabeth Esquire and Honorable Attorney General, I am dropping the gauntlet. You should also be doing something similar in Sierra Leone. And I can say next week, we're also heading to Zambia, where there's a very strong presence and growth of ADR, because the Chief Justice, the Honorable Dr. Mumba Malila, who is also a fellow of the Chartered Institute Arbitrators, also plays a very supportive role. So what I say, our experience shows that arbitration thrives when the courts adopt arbitration. Then I can tell you that this is so, and we have evidence to demonstrate this. When you train a judge, when you train a state counsel, they understand the dynamics of arbitration. So getting arbitration agreements enforced becomes rote. It becomes normal. So we normalize that. And we tell the courts, limited intervention. And we then have predictable standards for setting aside awards. The government as a policy enabler, it's important to think through, yes, we had the Arbitration Act for a long, long time, and then in separate spaces, we put in place the court annexed mediation. But we did it in the civil procedure framework. It's useful to do a national ADR policy framework, because then you get an opportunity to, first of all, have everybody come in. We had representatives from Parliament, both houses, our Senate and National Assembly. We had representatives from the faith-based sector. We had representatives from the consumer-based institutions. C.Arb was present. We had professional institutions which were present and represented. So when we negotiated the National ADR policy framework, not only the statutes, we all had a common understanding. And the net effect was that even while we are waiting for the acts to be enacted, Cabinet has approved this, but as we wait for the acts to be enacted, we find that people already, they've hit the ground running and they're adopting ADR in their spaces. The biggest, I think the most evident financial and economic impact has been through the Court Annexed Mediation Program. And this is a record that has been shared by the courts, that they have been able to release in the last 10 years through Court Annexed Mediation 103 billion Kenya shillings, which is approximately USD 798. So we're approaching the USD 1 billion mark. So when you tell the Kenya Bankers Association this is a success rate, then they get interested in adopting this. When you go to the different spaces in government as well, then they get interested in adopting arbitration and ADR. So the justice sector reforms should also be aligned with the investment goals. So the other, and this is on a social basis, in addition to the economic impact, the Chief Justice adopted as her philosophy, her theme, they call it the social transformation on access to justice. It's called people-centered justice. So there's also a social impact aspect to this. And once you embed it, because actually the pillar, the fundamental foundational pillar of the starch, you call it the starch, is that it is embedded in justice policy. So every time there's training, every time there's an activity, the focus, the thinking, the vision also incorporates ADR at its core. So for us, as C.Arb, we've been very privileged. I know I've been able to walk this journey the last 10 years, and actually just slightly more than 10 years. I became an arbitrator in 2012 and joined mediation and arbitration actively from 2015 and 2016. And we have been able to grow the impact of the institutions. We have been able to contribute to the development of the processes, whether it's in the judiciary, whether it is within the executive arm of government, and also now pushing into the parliamentary or legislative side of things. We've been able to work closely and keenly with all the institutions in this space, because we've also been able to tell all of them, if you do this, we have a ready body of neutrals who are available to be appointed. And this is how we appoint them. So the mechanism is available to all. Everybody knows how it's done. We have a national, a nomination, I beg your pardon, appointment services policy. We also have the codes of ethics in place. We also have outlined the disclosure duties, and I've talked about panel accreditation and oversight. This is at NCIA. And then we have the adoption of international best practices. So we have institutional rules. Okay, I've given the example of C.Arb, Kenya arbitration rules, but also the global rules and guidelines that are developed also become available, and we use them and we promote them and we champion them. Because, for instance, the Global Institute came up with guidelines on artificial intelligence. So if this comes up, we tend to raise it. So let's make sure that we prioritize integrity, procedural legitimacy from the onset. And I think that sort of brings me, yeah, there are challenges.
Thank you, Madam Chair Emeritus. I just wanted to let the chair know that the Honorable Attorney General is on the call, and he wanted to make a statement before he goes back in for the ceremony that I spoke about.
Okay, I think I can actually end there. I can share the presentation with you, and I will hand over back to Mr. Chairman. Thank you so much for your attention.
Emeritus.
Thank you very, very much, Abigail, for that. It's such a pleasure to have the AG with us. Just to give him a quick overview of what we've had until this point in time. I think what we've had generally is about the setting of an ecosystem that allows dispute resolution to thrive. So there's a history that's been shared, which will be of great value to both countries. I think what Sierra Leone is doing, obviously, is the next best thing from actual experience, which is learning from history, so you don't have to reinvent the wheel. We've heard about the parts of that ecosystem that makes dispute resolution thrive, and the questions around policy, institutional support, practitioners, quite a rich array of training with which you get the necessary practitioners in place, and other key sectors that support ADR and AJS systems in general, such as the judiciary. Ladies and gentlemen, now it is my pleasure to welcome on the platform the Honorable Attorney General and Minister of Justice of Sierra Leone. He's certainly no stranger to quite a few of us. I know the Solicitor General that I had mentioned earlier will recognize him as a personal friend, and that is the Honorable Alpha Sesay Esquire. I won't go into his very, very decorated profile, as I have not done for quite a number of the other panelists that are with us. So welcome, Mr. Minister. Such an honor to have you with us. We're just setting the context in this area of our discussion. Please feel free to share with us. Thank you.
Thank you very much. Thank you, colleagues. It's great to be here. First, apologies that I'm joining. I'm a little bit late. I'm actually tied up attending another state function with His Excellency the President, and so been trying to move in and out. But this is such an important event or an engagement. You know, the first that we're actually organizing as an office in collaboration with the steering committee here in Sierra Leone, and so I could not for anything miss the opportunity to make brief remarks and really to use this moment to say thank you to our colleagues in Kenya, for this partnership. I have said that, collaboration across borders is actually crucial to strengthening legal frameworks on the African continent. And of course, we talk about exporting these litigations beyond the continent a lot, when we could actually strengthen systems on the continent to make sure that we become the home of these processes that have significant impact on us. And our people and our economies. So it's really good that we are taking steps to build not only the legal framework, but also the institutional framework here in Sierra Leone. And of course, we cannot do it without having to lean on those with immense experience doing this, those we can learn a lot from. So we're really grateful that our colleagues in Kenya have offered to share their expertise with us. We are hopeful that this will not be the only time that we do this, because learning is a continued process. And, our systems are only strong if we grow together. If one system is strong, but the other one is weak, then we still have problems. So I'm glad that we are really doing this together. I'm really also grateful that we have a lot of participants. I see that we have more than 130 participants here. So we're really excited about the interest. Tells you that there's really the appetite for developing homegrown systems to these challenges. So we're glad that our colleagues have come on board to not only learn, but to be able to also share their own perspectives based on the experiences that they have had on the ground. We hope that, of course, the next steps will be to really strengthen these building blocks that will lead us to the setting up of the Sierra Leone Arbitration Center. So Sierra Leone becomes a seat of arbitration similar to what we have in other jurisdictions. So we're excited about this. Let this not be the last. Let's grow this together. And we know that in the coming days, we'll have additional trainings, which we all should be able to benefit from. It's been a learning process for me as well, being part of segment this morning. And I hope that whilst I am not present throughout for this segment, but that, like others, we all get to learn a lot about these processes while sharing our experiences. So thank you, colleagues. I'm really grateful that we're having this, and I wish you all really, really exciting discussions during the next couple of hours. Thank you.
Thank you very much. Thank you very much, Minister, for gracing us. I'm sure you recognize a few names on the platform.
Of course.
Quite a number of people of us, we have planning a trip to Sierra Leone quite soon.
Yes,
yes. We expect a delegation from this part of the world. I think the minister realized the importance of South-South collaboration. I think that's something that comes out quite strong. Certainly, we are in a paradigm, I think, which has essentially been mainly North-South. I think we're trying to grow that South-South linkage. The other thing the minister does speak to us about is how to make sure that this institutional framework is ongoing. Whether from a training perspective, I think he talked about what we often call CPDs, some kind of continuous professional development. What tends to happen is we often get the qualifications, but we need to build a lab where we support practitioners in keeping up to date, knowing when they're faced with certain dilemmas and proceedings and how to deal with those dilemmas. And then I think last but not least, I think he mentioned that this is the beginning of a building block that we hope to strengthen. And it's at this point, Minister, that you'll allow to welcome our global president. As you spoke about so much of what you said, I think you sense from his remarks and his vision, it resonates with what he has been trying to encourage between branches. And I won't hold this discussion any more as Mr. President, as we often like to say on this part, but Cesar, as you often prefer to be called, please feel free to take to the podium. I'm very keen on what this means. Just to give you a quick context, Cesar is held various portfolios, including at one time being the chair of the Brazilian branch. Now, Brazil is a very interesting country because it sits on the spectrum of that evolution where a lot of developing countries have been pushing their way up, whether it comes to industry, whether it comes to investment, and so forth. And more specifically from our end, I think it's a very useful part of the world because a lot of South-South relationships have been, we need to demystify them for various reasons. I think colonial past has sort of set us more aligned between a country in the south and colonial power in the north. Second, I think there are linguistic barriers that have sort of prevented a lot of information sharing across the south. So we'll be very keen just to hear from not just the global context, but also a bit of your experiences from that part of the world. Beyond that, and I marked this from the Deputy Minister, is the idea of research and how research can support this. So you will find that Cesar is an academic, and I think in the realm of authorship and writing on this subject, I think that would be very useful to know how we could leverage the idea of research in the journey that Sierra Leone is taking. So welcome, Cesar. So good to have you with us. As we say in this part of the world, karibu sana. Welcome.
Thank you, Kenneth. Asante sana. Is that right?
Yeah.
And it's a huge pleasure and an honor to be here on this webinar with the Minister for Justice and Attorney General of Sierra Leone, Honorable Mr. Alpha Sesay. And it's as you have indicated, Kenneth, and I'd like to highlight that to the minister. I am from Latin America. I'm from Brazil. In the 110 years of Ciarb's history, this time that we have a Latin American president. And so I have indeed, as Kenneth has pointed out, made it a very strong point of this 1-year term that I will have as president to stress the opportunities for collaboration, especially South-South collaboration. I was very privileged a few years ago to have been invited by the Kenya branch when Jacqueline was the chair, and I met Evelyn there as well, to attend the annual conference in Diani Beach. And that was wonderful. It was a very enlightening experience, really, to be able to collaborate directly with so many branches based in Africa. And as you have heard from Jacqueline and from Kenneth and from Evelyn, the Kenya branch is at the forefront of all the CIRB activity in Africa and globally. I would dare to say that it's probably, if not one of the most complete branches in terms of the reach of its activities. It goes much beyond the usual training in it, as Jacqueline highlighted. It actually has a crucial role in the development of ADR in Kenya in terms of being a reliable source for appointments of dispute resolvers, not only arbitrators, but mainly arbitrators. And so that shows how strong this partnership between Sierra Leone and Kenya can be in terms of developing ADR in Kenya. I really commend the Kenya branch for that, and I celebrate this opportunity for such a meaningful collaboration between the two jurisdictions. I would like to take these few minutes to just highlight some aspects that I think are important in this path of developing a strong ADR environment in Sierra Leone. Not only from what we heard here today, but from learning about what Sierra Leone has been doing in terms of ADR. I think there are some really important things. Of course, the 2022 Arbitration Act is a big step in the right direction of adopting an UNCITRAL model law based Arbitration Act, which is very important. UNCITRAL, as you all know, concentrates capacity from all over the world in best practices from many jurisdictions, and translates that into a set of legal provisions that jurisdictions, that countries may adopt. And so it's very good that Sierra Leone has adopted that, with some very important modern traits, as Kenneth mentioned before, such as third-party funding and emergency arbitration, things that have been adopted only recently by the UK New Arbitration Act, by the upcoming China Arbitration Act that will come into force now in March. And so we can see that Sierra Leone already ticks one of the most important boxes in terms of establishing itself as a reliable arbitration seat, which is to have a well-drafted Arbitration Act. Another trait that is very important is the fact that, as the minister mentioned a while ago, the Sierra Leone International Arbitration Center is in the on the verge of becoming active, and that is very important. What we have seen from many jurisdictions is the importance of arbitral institutions in the process of developing an ADR environment. In many countries, and I think that is very true in Africa, ad hoc arbitration has a very important role, and that is not in itself a problem, but arbitral institutions can develop the scale and can concentrate stakeholders and become a vehicle for development. And so arbitral institutions provide training. Arbitral institutions provide, in their lists of arbitrators or mediators, provide recognition of reliable professionals. And that is a role that certainly the Sierra Leone Arbitration Center can play from now on. I would like to share with you the experience that Zambia has had with the Lusaka International Arbitration Center. It was created in 2024. It has, so about 2 years ago, and it is now growingly active. It has a number of arbitration proceedings already ongoing, even if it has been created only 2 years ago. If you think about it, the global average is for an institution to start having ongoing cases within about 5 years from the date of its constitution. how did the Lusaka International Arbitration Center become active so fast? For basically two main reasons. First, it came from the CIArb community in Zambia. So the Lusaka International Arbitration Center basically reflects the Zambia CIArb branch's experience and the network of professionals that it had developed. And so that is translated into the Lusaka International Arbitration Center success. And on the other hand, it has received a very important government support with a lot of enthusiasm. The Zambian government has supported the creation and the development of the Lusaka International Arbitration Center to the point of starting to choose the Lusaka Center as the institution responsible for administering arbitration in some government contracts. That is a tool. That is a step that works as a catalyst for the arbitration market in a jurisdiction. The fact that a government chooses a certain institution recognizes the reliability of that institution and promotes arbitration in its own government contracts through that institution. That is a very strong sign for the private market still, so I would recommend that the Sierra Leone government takes that into consideration and maybe adopts similar actions that will encourage the market in Sierra Leone to look at the Sierra Leone International Arbitration Center as an institution to be used in that homeward trend of ADR. It's very important for many reasons to develop a home ADR ecosystem and environment, because that goes much beyond the direct impact of ADR in resolving disputes efficiently, but it encourages and it incentivizes the creation of a range of other services, of local practitioners, local schools, local translators, local court reporters. There are a number of services that go hand in hand with ADR. And so ADR is much more than a tool. It is a business in itself. And it's important for jurisdictions and for governments to be aware of that. In addition, I just want to make two more very quick remarks. In addition, it is, and as we have already heard today, it is essential for the success of arbitration or of ADR in general to develop for a jurisdiction to develop a knowledgeable and reliable judiciary. And I understand that is one of the reasons why arbitration is so successful in Kenya. And we heard that that many, or maybe all, of the Supreme Court justices are CIArb, are members of CIArb. So that is not a small thing. It's not easy to become a member of CIArb. We pride ourselves, I would say, in the fact that unlike other organizations, you don't really subscribe to CIArb. Even if you are an associate, that means you have undergone an exam, you have shown a certain level of knowledge of ADR. You have passed, you have been admitted, and that's when you are able to become a member of C.Arb. And every member of C.Arb, regardless of their status, is subject to strict ethical commitments, and is part of this global network of 20,000 people. And so it's not a small thing for Supreme Court justices to be members of C.Arb, and it's a huge thing for C.Arb to have among its members the highest representatives of the judiciary in any jurisdiction. And so that is something that I would imagine would be very useful for Sierra Leone to develop a close relationship between C.Arb and its judiciary, and in a judicial structure that favors ADR. What is that judicial structure? In many jurisdictions, there are specialized courts for arbitration, courts that will handle lawsuits in support of arbitration, that will handle set-aside actions, that will handle the judicial matters that create the framework for arbitration to thrive. Specialized courts, because that encourages judges to become themselves more specialized, to participate in conferences, to be invited as speakers, and to be aware of the reality of arbitration, to know. And so that is something that it is adopted in many jurisdictions, and is a good step to create that ecosystem that Kenneth was talking about. And lastly, I'd like to emphasize the role of this homeward thinking, also in terms of investment arbitration. We have seen with the Africa Free Trade Agreement, we have seen a great deal of development of this idea of intra-Africa collaboration, of a system for dispute resolution that does not rely only on the traditional ISDS system. And we have been now seeing a lot of development in terms of investment contracts that, instead of investment treaties, adopt more tailor-made scopes for investment protection, so that a state is not surprised by the impact of an investment treaty that was not necessarily thought of at the time a state enacts a certain regulation or measures intended to protect their population and their people. And UNCITRAL, UNIDROIT and ICC have now in place a working force that is working specifically on investment contracts. And I see that as an interesting path for development. And I know that Sierra Leone, during the Africa Free Trade Agreement negotiations, took a firm stance against ISDS in that agreement, and favoring other forms of dispute resolution. So as they are favor investment contracts, in try to see other forms of investment protection that go beyond the traditional ways. Well, with this, I would like to thank again very much Kenneth, Evelyn, Jacqueline, and for the opportunity to be here sharing this panel with all of you and with the Honorable Minister for Justice and Attorney General. And I remain at your disposal for any questions and comments and for further discussions about these issues that we have been talking about. Thank you.
Just brilliant, Cesar. Thank you very much. Quick highlights. I think the first, of course, is what arbitral institutions actually can do. So Sierra Leone is actually on the right path, but the secondary question, of course, is when you have these arbitral institutions, what then emerges out of them? I enjoyed listening to what you said, Cesar. We often think about the ecosystem that facilitates the establishment of ADR, but very few of us think about the ecosystem that ADR creates. And you talked about all these secondary players, translators, local practitioners, and so forth, and what that means for us. Again, for our colleagues both here and in Sierra Leone, we have a chance to localize our perspectives. I think a lot of the free trade area agreements, the CFTA particularly, is speaking about how we can own the dispute resolution process in that context of free trade and investment. And you did mention what has been happening. I think the new generation of BITs and a major emphasis on local issues, including the environment, labor rights, and so forth, so that investment is not, as it was in the past, pure, very economic focused discussion, but it takes into account what is happening in the local terrain. And then last but not least, I think colleagues will be wanting to chat around this, just lessons on what we can do with the judicial system. Arbitration has this idea of specialized courts is gaining a lot of currency because we may, I think for our colleagues in Sierra Leone, you may get it right when you set up all the other parts. But then if you don't have a judiciary that, of course, works hand in hand with what you've done, you may have what's been coined as the Ferrari tractor at relay in arbitration, where the tribunal moves fairly fast. There's great capacity there, but when it gets to the court systems, either through a challenge or some kind of a point of law and so forth, then you have a very a large clog where things do not move as fast. So thank you very much. At this point, I want to bring into the conversation two of our colleagues, very esteemed colleagues. One is Dr. Abayomi, and I believe, Doc, you're still on the platform. I bring him into the conversation because he had such a vital part to play in the development of the 2022 legislation in Sierra Leone. And I think he could offer interesting insights when it comes to the next steps, how you transition from legislation to effective practice, just in the background of what you said. And the other colleague, of course, would like to bring into this conversation is Abigail. And I kind of pick on Abigail because I know there are quite a number of other Sierra Leone colleagues, but I think we would like to hear about where you are institutionally. We had about the wonderful example from the Lusaka International Arbitration Center and how it upscales in terms of speed and the amount of work that it is doing, and the nuggets of this kind of secrets that you get from how that was done through the support that government has given to that center. So we would want probably to hear from our colleague from Sierra Leone, just discussions around those institutional structures. So welcome, Dr. Abayomi. Maybe you could tell us something. I think you were very heavily involved when it came to the legislation. How do you transition from where they are in 2022 to actually effective practice? Welcome. I'm sure I saw Dr. Abayomi somewhere.
Yes, I'm here. Thank you very much.
Yes.
I hope all of you can hear me.
Yes,
Let me start by first thanking Jacqueline, Cesar, and Prof for the excellent presentation. I've joined from the beginning and it's been quite revealing. So I didn't know I'll be speaking, so I'm not properly dressed or formally dressed like Cesar and Prof, so I don't have my jacket on. So permit me to speak without my camera on. Yes, so I mean, it's been quite an experience, supporting with the development of arbitration in Sierra Leone. So I'm truly excited to contribute to this important conversation. And for me, starting point is that Africa is at a decisive moment in its arbitration journey. Over the last decade, we've seen in different countries the passage of modern arbitration laws, establishment of arbitration centers, conferences organized under different institutions or bodies, and a number of things that are going on or moving at the moment. But arbitration development is not, as I understand it, measured by legislation alone, nor by the number of centers that we've launched or that we have. It is measured, like Jacqueline said, by trust, credibility, and sustainability. And those three keywords I picked out from Jacqueline's presentation. The real question is not whether arbitration exists in Africa, it is whether arbitration in Africa commands that confidence from the parties on the continent. I've been involved in a number of high-value market-defining transactions where parties will insist of either having a seat in London or in Paris or having institutions outside Africa. And that must change, or that should change. But for that to change, parties must have confidence in our courts, must have confidence in the expertise of the practitioners within the continent. So one thing is clear, no single country or institution can build that confidence alone. If arbitration is to mature sustainably, it cannot develop in silos. So Nairobi cannot do it alone, Freetown cannot do it alone, Accra cannot do it alone, even in Lagos. So even those of us who spend too much time in airport lounges, speaking on panels, cannot build a continental system from conference rooms alone. So the future, I believe, lies in structured collaboration, such as the one we are doing now. Collaboration between the East and the West, between institutions and government. Regional centers sharing best practices for exchanges, harmonization discussions, having reciprocal cooperation agreements and shared training initiatives. When one African country or African center grows stronger, the ripple effect is that it strengthens the continent and help us to build that confidence in doing arbitration in Africa. So trust ultimately, as I understand it, is the currency of arbitration. Parties must believe that arbitrators are competent and independent. They must believe institutions are professionally admitted. They must believe that the court will support arbitration rather than supervise it into extinction. And I mean, I'm happy that a number of the judiciaries in different countries in Africa now adopt pro-arbitration approach, but we need to continue to engage with the judiciary. I mean, partnership with the judiciary, I mentioned this in the morning session, is indispensable. Courts should no longer see themselves as adversaries to arbitration. For Sierra Leone, we'll continue that engagement with the judges. Last week when I was in Freetown, I spoke with the Chief Justice, and we're already planning engagement with the judiciary to continue to walk them through what should be that important collaboration with the practitioners and with institutions in Sierra Leone to advance the development of arbitration. So it's an important dialogue that we should continue to have. It's also important to acknowledge that Sierra Leone today stands as an example of legislative progress in this space. And I'm proud to say, not only because I was in supporting in the drafting, but also because I know, and Cesar said, we have useful provisions like emergency arbitration, third-party funding, and those modern provisions. Sierra Leone today now has one of the most modern arbitration laws on the continent, and I dare say, even around the world. And these provisions align with contemporary international standards and reflect best practice in party autonomy, limited court intervention, and enforcement of awards. The conversation we are having today is not only on the development is not only a symbolic achievement, it's a structural one. A modern arbitration framework sends a powerful signal to investors that contractual commitment will be respected and that disputes will be resolved in a predictable and neutral forum. And over time, such legislative clarity will have a ripple effect, strengthening contract governance, improving commercial discipline, and also enhancing investor confidence. So when dispute resolution systems are credible, capital becomes more patient, project becomes more bankable, and commercial relationships become more stable. So we can't overemphasize credibility, sustainability in the process. And one other important thing, which is, always at the core of whatever I say, or when I'm speaking in fora like this, is that localizing arbitration does not mean isolating ourselves from the global system. I'm all for domesticating arbitration. It also means we should contextualize that domestication. Many African disputes, particularly in infrastructure, energy, and public partnerships, PPP, have unique regulatory and developmental dimensions. We need to continue to evolve, gain expertise. I'm involved in a number of arbitrations now, infrastructure, energy, projects, construction, all of them, African-related parties or African parties, but they are all seated in London or in New York or in Paris. We need that narrative to change. We need cases related to Africa to be resolved in Africa. And to do that, to attract important references, we need to continue to evolve, continue to build expertise, continue to develop continental collaboration like this because it's very critical. The Africa Arbitration Academy, which I'm one of the directors and the founder, we are at the forefront of helping to achieve this promise. That Africa arbitration future must be built by developing African capacity is very, very important. So if we're honest, what we need to do is to develop capacity, have supportive court systems, have credible institutions, and build collaborations within ourselves. And with that, we'll start attracting important references. And also, I always say these Africa-related cases, except where you can't avoid it, should sit in Africa. Africa does not need to replicate what other regions are doing. We need to build confidently in our own voice. If we prioritize collaboration over competition, integrity over symbolism, sustainability over speed, arbitration will not merely exist in Africa, it will lead. The next phase for arbitration in Sierra Leone is driven by the Office of the Attorney General and the steering committee that has been established for that. And I understand that establishing the Sierra Leone International Arbitration Center is at the forefront of, pushing that development. We'll continue to support that. And again, many thanks to Ciarb Kenya for helping with this collaboration. Thank you very much.
Thank you very much, Doc. And the African Arbitration Academy has been a central part in the question of developing capacity across the continent. I think keywords that immediately will strike all of us is how the business of arbitration is closely linked with question of trust and the dividend that you get there. So I think the entire system of confidence, trust, credibility is at the heart of the discussions that we're having at the moment. I think of equal importance from Dr. Buyomi's comments is the importance of collaboration across the continent. I think we've seen a multiplicity of centers being opened in different countries, and constantly we're asking ourselves, how do we get all of these jurisdictions to work together for a common cause? I think last but not least is this word, sustainability, and how we can actually arrive at this, when I use the word local to mean almost continental, a lot of this work being sort of embedded in the continent, not necessarily to the exclusion of other areas. Of course, we're in the area of investment and commercial disputes and matters of that nature. But how can we see more and more Africa and African seats, featuring not procedurally only also, but in the language of venues. So thank you very much, Doc. You made reference to the next stages and what that looks like for Sierra Leone, and you referred to the steering committee that closely works with the Attorney General on implementation. At this point, I'd like to invite Suleiman Kaba Koroma to speak on that. Suleiman, it's so good to have you with us. We have met in some of the courses, so it's really, really great that you could join us. Would you like to make some comments on what those next stages look like? We've had a lot about questions around capacity development, how you actually build user confidence, the whole exercise in public awareness, what you're doing when it comes to what Cesar was speaking about earlier, the role of government and how government is a key player in bolstering the environment and so forth. Welcome, Suleiman. Just check whether you're able to unmute from where you are.
Yes, I am able to unmute, Professor.
Yes, please. The floor is yours.
All right. Good afternoon once more. Sierra Leone has come a long way in the arbitration world. We used to operate under Cap 25, which is one of the colonial legislations that we inherited, and a lot of deficiencies were in that act. So through the efforts of government and private practitioners, we are able to have the Arbitration Act of 2022, also with help from Abayomi and team. And then this act was passed in 2022. So you can see that we came, you can see that we came to the scene very late as an arbitration country. But however, we try to ensure that we have an arbitration act that is not only robust, but one that is user-friendly and one that can do arbitration into Sierra Leone. So when this act was passed, we still don't have a physical structure of the Sierra Leone International Arbitration Center. So as a group, we decided, the then Chief Justice, D.B. Edwards, called for a meeting of all arbitration practitioners, and then the steering committee was set up. And we agreed to see how we can have these arbitration acts implemented. The courts are implementing the acts, but we tried as hard as possible to ensure that the courts have a limited role in terms of arbitration. Yes, they do refer parties to arbitration, but what we have as domestic arbitration is ad hoc arbitration ongoing. We don't have yet a Sierra Leone International Arbitration Center. So when the steering committee was set up, the Attorney General was very instrumental in saying that they will need to come in to help. But we try as hard as possible not to have government control over the Sierra Leone International Arbitration Center. So we decided to see if we can have a seed that we can start to set it up so that it can cater for both domestic and international arbitration. And when we met with government, it was agreed that we can have a seed money to set up the physical structure. But we had also discussions with Professor Abayomi. You came to Freetown. We had discussion that first of all, we need to have the institutional infrastructure. Where are the rules? So we're trying to set up the Sierra Leone International Arbitration Center rules. And then once we have set up these rules, we are also trying to see how we can have the Sierra Leone International Arbitration Center board constituted, because we want to attract brains within Africa that can help war arbitration into Sierra Leone. So the board is not yet constituted, but we're trying to see if we can have eminent Africans, arbitration practitioners on that board, and also Sierra Leoneans on that board. And we're trying to open up the arbitration space in Sierra Leone, in as much as it's a new act. There's a lot of enthusiasm from young Sierra Leoneans to participate in arbitration. We want to diversify the arbitration practice, not only confined to international commercial arbitration, but also to go into the construction industry, to go into the maritime industry, to go into the sport arbitration industry. So as it stands now, government is trying to push for a training which comes up physical in person next week, in which we'll have organ levels and others coming in to do training. And also our women are not left behind, because we try to see that our women are part of the discussion. So we have the ADR, the Alternative Dispute Resolution Women in Sierra Leone. They come up together, in as much as they are all women, they do have some men in their group that help in shaping up their own policies. So as a start, we are trying to see how we can have the infrastructure kicking. I heard what Cesar was saying about the Zambian model, and we saw the commitment he was saying that he got from government. We are also trying to get that commitment from government, wherein all future agreements to which the government of Sierra Leone is a party and to which arbitration is chosen as the means of dispute resolution, to have a clause to state that this dispute resolution should be resolved within Sierra Leonean International Arbitration Center and not elsewhere, provided the other side agree to it. So we try to see how best we can hold people to come and use this Sierra Leone International Arbitration Center. And God willing, we've pushed ahead to have the rules. We're still starting to have a committee to draft the center rules with the help of Abayomi and others. Once we have the rules, we'll be moving next to have the physical structure, so that when there is a domestic arbitration or an international arbitration, it can be filed at the domestic Sierra Leone International Arbitration Center, wherein it can be looked upon. We have a roster of arbitrators. And as I said to you, there's a lot of enthusiasm for arbitration in Sierra Leone by Sierra Leoneans who are doing well. A lot of practitioners are doing well in the local sector in domestic arbitration, but want to see how we can blend it to give effect to this act. As you rightly said, in our act, we now have provision for an emergency arbitrator, the method used in appointing an emergency arbitrator. We have also ratified and part of the New York Convention, the enforcement of arbitral awards. So Sierra Leone, even though we come in late to the scene, we're trying to catch up. We're trying to see how we can also integrate other sectors like the Institute of Sierra Leonean Engineers to go into the construction arbitration and see how we can get them. We have few Sierra Leoneans who have also done masters and other areas in maritime arbitration. So we're trying to move it, and we try to emulate other examples. Zambia was quoted to us as a model to try to follow, because in as much as it's a young center, they're trying to, as hard as possible, to get enough arbitration in their country. So we're also trying to push and see if we can get the same support the Zambian Arbitration Center is having, and see how we can move forward. But for now, we have the support. The fact that we even have this training done by the Office of the Attorney General, it shows the commitment this Attorney General wants us to have with regards to having arbitration going on. And we are also seeing this as an issue of access to justice, because here we have a lot of business coming in. We have the mining sector. We have the people in the oil and gas sector. Once we have a proper arbitration functioning, they will stop going to the courts in terms of settling disputes and then choose the arbitration method that can become easier for all to see. So we are moving in that direction. And from a Sierra Leonean perspective, we want to learn, we want to exchange ideas, and we also open up to future trainings, because we have a very young bar of over 2,000 or 3,000 lawyers who wants to get more knowledge in arbitration. If you can see, the number of people you see today on this program shows the enthusiasm in which young practitioners want to get into the arbitration field. Not only the commercial aspects of things, but the maritime aspects of things, the construction aspects of things, the energy aspects of things, energy charter and every other thing. So for now, this is what we are doing as a country, and we are trying to see how best we can embrace. And as I said, we are willing to have exchange programs. We're willing to learn. We're willing to have more people enroll to go through the Ciarb path, either through Kenya or through Nigeria or through the UK chapter, so that they can be armed with the knowledge in arbitration. I thank you, Mr. Chairman.
Wow, Suleiman, that's fantastic. I think that is just absolutely mind-blowing. I see Caesar's hand has already gone up. I really would like to give as much time to the panelists and everyone else to weigh in. I'm sure a lot is being triggered from the comments, particularly the comments by Suleiman now. I welcome Caesar. While you are speaking, I'd like you just to so maybe make reference to this fine line of government support and yet the importance of independence, which Suleiman sort of highlighted, because many times government is the center of those disputes. Welcome, Cesar.
Thank you, Kenneth. And actually, that was precisely my point. I enjoyed very much what Suleiman talked about, and it's very exciting and promising what he described. And I completely agree with what he said, that the government should not be the one sponsoring or funding an arbitration institution. And that is precisely what happened with the Lusaka Arbitration Center. It was formed by, I believe, 8 different organizations from the private sector. What the government did was give its institutional support and in a way confidence in choosing that institution as the one to administer some of the government contract cases, which is a strong signal to the market of the reliability of the institution. So I think that is what one of the main roles of the government. And I completely agree, as I said, that the government should not be the one backing up financially the institution, because if it is, that will greatly compromise the independence and even the reliability of the institution. And so it's something to be taken very carefully, how to structure this government support. But it is important to have this government support. And I can tell you about the Brazilian experience. It's a little it's a little flipped from the experience that maybe Sierra Leone will have now, because arbitration in Brazil started as a private as a private form of dispute resolution, and only later the government undertook it. But the government started to have a very important role because government disputes are usually large. In according to Brazilian law, and that is something that I would recommend to Sierra Leone if possible. According to Brazilian law, those disputes are public; they are transparent, and so access to the records of the arbitration, access to the awards, is public. That means that the market can be aware of how arbitrators have decided, how efficient those arbitrations are. And that is, again, a catalyst of quality, of reliability. Since Sierra Leone, as Suleiman mentioned, is coming late, but catching up with all the best practices internationally, that is one that I would recommend. Think seriously about making public the government contract arbitrations, so that those arbitrations and the awards coming from those arbitrations can be resources in the development of arbitration in general. And so you are in the position now of using the size and importance of government disputes as a tool in the development of that ecosystem of arbitration in Sierra Leone. So that was my comment. Thank you, Kenneth.
Yeah, which almost opens up another discussion. I can see we're almost into time, because the idea of making public these arbitration contracts is an important discussion. As you know, one of the major pitfalls, if I may use that word, is in the past has been how the idea of confidentiality plays out vis-a-vis questions around integrity, the size of awards, and so forth. So that is a conversation for Friday, and we will have Cesar in the flesh, as they say, here in Nairobi. I would encourage all of you to be a of that conversation at the Serena Hotel. Evelyn will give us all the details. In addition, I think there's been a lot around how Ciarb Kenya can support the process. Of course, Ciarb Kenya has been essentially a mother branch on the continent. It's given birth to the other branches that you see, many of them very active and strong. Again, Evelyn will speak a bit around that. And of course, Ciarb Kenya did play the pivotal role in setting up of the Nairobi Center of International Arbitration. Some very interesting lessons, if we have more time on what you just spoke of between Suleiman and Cesar, on how to get it right so that you have an entity that has, as it were, government support, but not government intrusion. So this is a very important fine line for us to probably discuss now that Sierra Leone is on that journey, and they could actually strike the right balance. Allow me to say thank you very much to the panelists. I would like to our CEO just a few parting remarks, a lot administrative events that are coming in the week. I'd mentioned the public lecture on Friday, and it would be nice to hear from her in that regard. Great comments that I've seen on the chat. I want to thank everyone that's taken time to make those comments. Alpha, very impressive. Janabu, very insightful. Stephen Orina, this has been quite insightful. Please look at what Dr. Engineer Paul Kioko has said, because he frames the discussion from the perspective of an engineer, someone professional in the built environment, and how I think if you really read behind his comments, the major danger, the professionals from that part has been the lawyering or the extension of the court modalities into arbitration, and how that doesn't support projects and what the stakeholders in projects hope to achieve. He basically says that their interest is they would assess arbitration for our colleagues in Sierra Leone by how well it supports the sound outcomes of project, which is actually timely completion and the protection of the built asset. So this is a very, very key for you as you start to move into the world of infrastructure and also maritime disputes. So thank you. I can't exhaust all the comments, and very special thanks to the panelists. Thank you, Suleiman. Thank you, Dr. Aboyomi, for joining on very short notice. Much extended thanks to the minister. We understood the constraints that he had. We're so glad that he was able to speak. Thank you very much, Jackie, for the comments that you made, sort of laying out the critical path that we followed. And a very, very big thank you. So Cesar, in the ordinary nature of culture in this part, we always provide the biggest thank you to the one who comes from the farthest. So you, by all intents and purposes, coming from as distant as Brazil may be, the number of hours, and we're very, very glad that you could grace us with this session and the rich conversation that you added to it. So Evelyn, I'll yield the floor to you. Welcome, maybe a few remarks just before we adjourn. Thank you.
Thank you, Chair, and thank you to our panelists for such an engaging, interesting, and inspiring session. And I'm very sure that our colleagues from Sierra Leone have at least gained a number of insights. And again, we reiterate by saying that we are here as the Kenya branch to support the initiative. We're here to support the capacity building that Professor Bayomi has said is very, very key. And I can attest to that. Some times back, the narrative was Africa was not ready, Africa didn't have the capacity. But from the stellar panel today, that is no longer the truth. We have the capacity, and if not yet, we have the resources to ensure that the capacity is built within the various jurisdictions in Africa. So as a branch, we are willing and we're ready to provide that help, that capacity. As I mentioned in the opening remarks, we had an initial training last year, Introduction to Arbitration, for a number, I think about 20 or so of our colleagues from Sierra Leone. And we'll continue having these engagements. And since we have the direct line with the Office of the Attorney General, and I've seen some of the comments requesting for that information once it's made available, we'll ensure that we share that immediately. We curate that particular program. And we already some steps ahead. We will not only curate programs around introduction to arbitration and the modular progression training, but we'll also take into consideration the special circumstances within which Sierra Leone is in terms of capacity around the, drafting arbitration clauses, capacity in terms of enforcement, capacity in terms of in terms of even these other sector-specific dispute resolution mechanism. So we are ready and willing to do that, and we'll continue these engagements to ensure that we bring this to fruition. Now, in terms of the activities that we have in store, I know, Chairman, by the virtue that you're here and the President, you're also here, that gives me at least the power or some sort of power to say that Sierra Leone, you're very much welcome to the Ciarb Kenya family. So please feel free to follow us on our social media platforms, because we have so many platforms such as this in terms of thought leadership, and most of them are actually free. So follow us on social media so that you also get insights into what is happening across the globe. And I can assure you that we not only just bring local content, we're also geared towards the international market as well. So whatever it is that we curate and discuss within the Kenya branch, it's very relevant even for you down there, for you in Sierra Leone. In the activities that we have lined up, the chair has alluded to one, and the fact that we are expecting presidents to come into the country from tomorrow. We have a public lecture where we are addressing the very important question on arbitration on trial. So for us, we're not only just ensuring that we are promoting, we also need to question and address so that whatever conversations we are having are relevant and are progressive. So we'll be speaking on the very theme the President has on trust in arbitration, and to ensure that we also bring you on board. Yes, it will be here in Nairobi, but we will also have a virtual platform, and we'll make sure that we invite you to that one as well, and you can be part of those discussions. Over and above that, we have activities lined up for the rest of the year. We'll be able to share the recording. Yes, first of all, the recording of these events. It will be shared on our YouTube page, but also we'll be able to share the PowerPoint presentation by Jacqueline to your email addresses. Alongside that, we'll also be sharing our calendar of activities and events, so that should you find one that resonates with your interests, you can always you can always apply and be part of it. Moving forward, this is just but the beginning of these engagements. The chair has said that we are long partners, we are collaborators. We'll ensure that this keeps on happening so that whatever it is that you need and we can be able to give, we are able to do that. And also to challenge, allow me to put through a challenge. For an effective dispute resolution framework to be successful in any jurisdiction, We need every stakeholder on board, from the government to ensure that the policies and the frameworks are in place, to the people themselves who will be building capacity to run with this dispute resolution engagements, to the professional bodies. And that is something that Ciarb has been very keen on doing, where we have partnered with most, if not all, the professional bodies, so that to ensure that arbitration is not just within the legal system only. We are taking it to the built environment, to the insurance, to the finance and banking and all these other stakeholders. So with the systemic acceptance of dispute resolution, then its implementation becomes very, very easy. So this we did in partnership with the Office of the Attorney General. Should then another sector be willing to, get some bit of insight as to how they can contribute to that, we'll also be willing and ready to do that. So thank you very much. This has been a very, very insightful and great platform. Thank you for everyone who has joined us from the beginning to the very end. Thank you, Dr. Bayomi. I am a beneficiary of the Africa Arbitration Academy, and it's actually because of that I met Abigail here and how this conversation started to come about. So people network. And we'll be having our conference in the course of the year. So once that information becomes available, we'll share it with you. And it is one of those platforms, as the president said, he also met us a few years ago when he joined us in Diani, that you can be able to make friends and have impactful conversations. Thank you very much, and we hope to see you the next time. Thank you. Kwaherini.
Thank you very much to all of our speakers, starting with Mr. President, on behalf of the Office of the Attorney General and the Minister of Justice, the Deputy Minister of Justice, and on behalf of all of the practitioners and ADR practitioners joining in from Sierra Leone, we want to say a very big thank you. And also to let you know that many people are already signing up for the upcoming training. So I'll be happy to share names of people who want to be certified, because the questions have been coming, how do I go about, how and when? So we are really happy for this collaboration, and we look forward to further engagement in this regard. And Karibu.
Well done, Abigail. Okay, Karibu sana.
Thank you.
Thank you. Goodbye, everyone. Thank you.
Thank you.